It's the Holderness Day of Giving. I bet he's busy.
No, he called and said he has nothing.
Keep getting texts.
So John's going to
I said, go get 41.
Mike is not here.
I believe.
Get a ball at 41 ton.
And Mark's not here, so that means that you can seat
And as soon as
Peter.
they put it on there, they broke free.
Mike?
I was scared. Everybody was
Mike
looking
or
up.
Mark, it looks
It's a
like.
state-
Mark's not going to be here. I think you were CC'd as well,
I
right?
believe so. Yep. I think I
I
saw
was so
that.
confident about everything.
Mike, have you heard anything from Mike?
It's Jack Conway has to
I
fold those
don't believe I have an email. I'll check.
If you tell me right, you know, he's not in pipes. It breaks 40 tons. Reaction is an opposite reaction. It can hold 40 tons too when it's frozen. Anyway, it's scary.
Probably lost a few years of your life, didn't you?
Well, either way, 6:30. Let's get started. All right. So it is 6:30, and I will call our planning board meeting to order. And there he is. And I'll begin with the roll. Rebecca?
Here.
Phil?
present.
Neil?
Present.
Mike? Here. And Mark is excused. And Susan?
Here.
And then we have our alternates, Zach, Michael Bouchard,
Present.
and Peter Julia.
Here.
So we have, we do have one absence on the board tonight, so we can fill that with an alternate. And I guess, Michael, you've been here longer, so we'll seat you as a voting member this evening.
Thank you.
And Peter, feel free, of course, to join in the discussions, and we welcome your input. All right, so next up, we have the review of minutes from our previous meeting of February 2nd, 2023. Emphasize the 3 because I always pick these small little typos up and stuff.
On the agenda.
Yeah.
Yep. Correct.
I'll make a motion to approve the minutes as written. Second.
Any further discussion? All in favor?
Aye.
Opposed?
I'm
Abstentions?
abstaining.
Okay, abstentions. All right, so the meeting minutes are approved of February 2nd, 2023. Have there been communications received by the board?
Actually, yes, there has been a communication received, and it's on the table. So the Town of Plymouth has 2 commissioners who sit on the Lakes Region Planning Commission. Currently, those 2 commissioners are Zachary Terrell and Bill Bolton. Both of their terms are expiring at the end of March. And per state statute, the planning board is responsible for nominating the commissioners, and the select board is responsible for appointing. So it's sort of a 2-step process, but the planning board is sort of the initial step, and then the select board approves them. So the select board has sort of spoken about this at their meeting on Monday, and perhaps you can speak to it as well. My understanding is that they would like to request Bill Bolton be nominated as a commissioner with Zach Terrell as the town's alternate, and they've also asked if a planning board member could fill the other commissioner seat. So that it doesn't have to be determined right now. It's not until the end of March that the terms expire, but something for the board to consider if any members are interested. The Lakes Region Planning Commission on their website has a commissioner handbook. So if anybody wants to review that in the meantime and see if it's something that would be of interest, broadly they are responsible for coordination and collaboration and planning efforts, including transportation planning for the whole Lakes region. But if that's something I suppose the select board has asked if a member of this board would be willing to join Bill Bolton as the town's appointed commissioner, serving in somewhat of a similar role, monthly meetings, but that commissioner handbook is really a great place to take a look if you're thinking about if it's something that would be of interest.
So I've got an agenda for a future meeting coming up. And if anybody, so everyone should give it some thought. I actually sent a message out to Bill, given that he's a current rep on that committee, just to see if he had any thoughts about time commitments and that sort of thing. From actually like feet on the ground as opposed to the handbook, which can be, hard to kind of judge reality from sometimes.
I think this is a great opportunity for the planning board.
Yeah, absolutely. Okay. So we do have two applications and public hearings this evening, and the first of those on our agenda for the evening is a continuation of the public hearing for the Frontenac Act development. And it's my understanding that we have not received updated information or necessarily really a timeline at this point. Is that correct?
That is correct.
So we do have a public hearing scheduled for this evening, and Jeff Hiltz, who has been representing Frontenac development, is not going to be here this evening, I believe, right? Checking the audience. And so we will still hold a public hearing, and if you want to be heard, absolutely say your piece. And unfortunately, at this point, we can't really specify yet when we will continue this hearing till, until we hear back again from Jeff Hiltz with more information. And that's kind of where we're standing right now, yeah.
Yeah, so the board, continuing a hearing, the board, should specify a date that the hearing is continued to. However, at this time,
Don't really have a
it
date.
has not specified when more information will be ready, so I do not have a timeline from Jeff Hiltz as far as when he would like the continuation to be to. So
I think we just have to keep continuing it until the next public hearing,
Until next work session? I mean, next public meeting?
which is March 16th.
So I don't know how much conversations you've had. I don't want to announce another public hearing and then have people show up and not have the actual applicant here. Do you think a 1-month extension seems? I know it's hard to speculate on somebody else's behalf.
Mm-hmm.
I'm just wondering, how much information you've gotten.
yeah, as of our most recent conversation, I did ask, and he said that at this time he does not have a timeline to present or a specific date that he's requesting the extension to. He said that he would he would let us know when he had more information, but at this point he's just requesting it be continued.
So, as a technical kind of point of order, if we choose a date this evening to continue the meeting to, and we don't yet notice it, because we don't have to notice it for another couple of weeks yet, do we still have to notice that meeting if we've agreed to continue it to that date?
So the continuation is a little bit different from noticing a new public hearing.
No, I know that. I'm trying to see how the two of those coordinate with one another in terms of if we do officially continue it to a month from now,
Mm-hmm.
Are we required to hold that public hearing and notice that public hearing?
The public hearing does have to be, so if a hearing is continued, it's, the initial posting is sort of the posting for the continuances of the hearing. So it would be, the hearing could still go forward, but, if you announce that the hearing would be continued, there would have to be the hearing at that time.
And we would have to continue it at this point anyway.
Yes.
I would think that,
So I guess we can recontinue at that meeting without necessarily noticing to everyone a meeting to come to.
John?
Yes.
Maybe it would be helpful to know if there's anybody here from that subdivision, just so we can get a sense.
Well, I do want to, we still are obligated to have a public hearing this evening, and we will hear from anybody who wants to speak. I'm just wondering when the actual applicant is going to be ready to actually address the public at a public hearing.
No, I know what you're.
And what our obligations are if we continue to a meeting to a month from now and it's still not ready and we still have to hold yet another public hearing and.
Yeah.
I'd rather err on the side of having it ready
Okay.
to go.
Yeah.
I think just in the interest, from what I'm understanding from the homeowners up there, that if it's better to have it on the books.
Yeah, fair enough. So we will not continue yet, but just kind of trying to get the sense of the lay of the land here.
I would say that if you want to keep this hearing going, that, a continuation, there is the difference between posting a new hearing and continuing the hearing. So the initial posting has occurred, and, the abutters were notified, and since then it's been continued. So a continuation would allow, under this current posting to continue versus a new.
I was just wondering about one part of that process triggering the next part. And anyway, so we'll get to the continuation in a little bit. It is currently 6:40, and we will continue our public hearing on the front-and-act development. Are there members of the public who would like to speak? And if so, please come up to the podium, identify yourself, and...
Good evening, Dan Marion, 19 Point of View Drive. This meeting is keeping me from my dinner at Yama's, so I'll try to be brief, okay? My wife and I, Christine's right behind me over there. Say hi, Christine. We bought the lot on Point of View Drive in March of 2021. And construction started in June of 2021, and we moved in June of 2022. So we're very new to not only the Plymouth, but to New Hampshire as well. We did a lot of homework before committing to the build, and we knew that the roads were private and had received enough information regarding future dedication to commit to the build. So we were okay with that. Okay, my wife, Christine, unpeeled that onion to make sure that there was not going to be any roadblocks or anything like that. Regarding the sewer, all our documents show that the sewer system within the subdivision was public. Now, we understand that the PVWSD is a separate entity from the town of Plymouth. We get that, and we understand that. And I'm not here to talk to you specifically about sewer, but I do feel that we need to bring sewer into the discussion, even though you don't have any control over the sewer issue. But we also feel the dedication efforts should be spoken about at the same time, even though the efforts are on different paths with different requirements. We understand that as well as all the homeowners and lot owners that are in the subdivision. I want to show you a couple of things. The first is a real estate listing. This is actually our real estate listing from 2021, and I've highlighted in yellow what's most important. You'll notice that in yellow, they said the roads were public, and we already knew they were private, so that's why I put in my handwriting, private, are you kidding? Well, I knew they were private to begin with. What we didn't know is that the sewer system was private. It said public, and as you could see from this listing, it says public. The next thing I want to show you is our seller's disclosure, the people that sold us the lot. That had the opportunity. If you look at a seller's disclosure these days, it has an opportunity to put down private, a checkbox for private. The seller checked public. If we were looking for an existing house, a 3-bedroom house, when you look at real estate listings on the Zillow for 3-bedroom houses, you don't question whether it's 3 bedrooms or not. You just assume that what you're going to be looking at is a 3-bedroom house. Now, I never questioned, my wife never questioned whether or not the sewer was private. It wasn't a question that was going to come up. We didn't think about that. You just don't think about those type of things. So it was very disturbing to us to hear that, I think it was in December, one of your meetings I was on virtually, to hear that the system was not only private, but that the developer did not get any of the sewer infrastructure inspected before backfilling. And that's what brings me here today. A Couple of notes. We do commend the planning board for following established rules and regulations to ensure all punch list items, including the current detailed as-built, have been completed. Without you doing that, you're not doing your jobs. And we appreciate the fact that you're doing that to make sure that 10 years from now, when something comes up, and we're still living up there, God willing, that you have the right documentation in town to refer to. We commend Mr. Hilt, actually, and he's not here to hear it. We do commend him for his efforts to address the town punch list as evidenced by new course paving, new guardrails, etc. He does have a long way to go for both road and sewer dedication, but, you know, give credit where credit's due. I want to commend the planning department staff for educating all of us the proper way to navigate and review the approval process. That includes Joseph, that's present, and June, I guess she's not online. Their leadership does not go unnoticed by the citizens. So I want you to know that we appreciate all the efforts that they've been doing over the past several months to keep the train on the tracks and to make sure that you make the right decisions. I met with Scott yesterday, Scott Whedon, the town manager. Of the topics that we talked about, I said this to Scott, and I'll quote, "We, the homeowners and lot owners, continue to develop a timeline based on the data that we've received and collected of the subdivision activity and decisions made or not made. The timeline is extensive and it continues to grow." What I'm talking about is all the research we did to receive planning board minutes back from as early as 2002 to current date, PVWSD minutes from that time to current date, as well as BOS meeting minutes from that time to current date. Hundreds and hundreds of files, and we appreciate the staff for providing that. Our early analysis reveals that there were missteps by the town, by the water and sewer district, and by the developer. And let me repeat that. The timeline is extensive and continues to grow. Our early analysis reveals there were missteps by the town, the water sewer district, and the developer. Now, I'm not a lawyer, I'm not an engineer. I'm just telling you what we're reading and what we're fact-finding, okay? That said, we're looking for the town, planning board, the select board, and the PVWSD to work together with the developer to ensure the homeowners and the lot owners are not financially harmed. We bought into this community based on what we thought were sound facts. And when the facts are not facts and it goes astray, we shouldn't be financially harmed by this. Lastly, there's been some water and sewer district correspondence as well as planning board public meeting discussions about this division forming a homeowners association. I can tell you with high confidence that nobody in the development is willing to form an HOA for the purpose of assuming maintenance of either the sewer infrastructure or the roads. There is nothing in our deeds that mentions an HOA. Furthermore, we continue to feel the developer should be accountable for ensuring both the roads and the sewer infrastructure are dedicated to the town and the water and sewer district respectively. I'll be happy to entertain any questions you have of me.
Thank you.
Okay.
Would anyone else like to speak? Is there anyone online, Joseph?
We have about 6 or 7 folks on Zoom. Nobody has raised their hand, but
Okay.
You want to offer to anyone who could unmute or raise a hand?
Is there anyone online who would like to speak? You may unmute and speak.
Hi, this is Julie Bernier. Can you hear me?
Yes.
I won't reiterate what Dan has just said, but I will just add that, excuse me, everybody that I've spoken to in the development has the same story as Dan, and that is about the advertisement for the property and the seller's disclosure stating public on the sewer. And I just wanted to note that we actually bought our property from Jeff and his business partner. So in Dan's case, he was buying, and many of the others, they were buying their property from another owner. But we actually bought it from the developer who checked off that the septic was public. So I just wanted to put that on record and so that everyone would know that.
Thank you. Any further comments? All right, so,
I would suggest we continue to March 16th.
I was just gonna look up the date, thank you. So with that, it is 6:51, and we will continue this hearing to March 16th, 15th, 16th? 16th. For those of you who commented, thank you very much. It is very much appreciated, and yeah. Thank you.
Would you like your real estate documents back?
You can have those copies.
Okay.
Hey, John.
Mike?
I don't know if I just kind of want to review 3 months ago or 2 months ago, whenever Jeff was here. It was pointed out about the septic. Normally, you own the line to the roadway, if it's a public roadway. And it's still a public septic, but it's only, from what we were told at that meeting when Jeff was here, the septic for you folks, instead of just going to the roadway where you hook up, it actually continues on some of those main lines, picking up more and more houses till it gets to off the
Parker.
development. And then from there, it travels publicly to the public septic system. So there is some responsibility for the lines to that point before it becomes public. And that's what was pointed out. And so who knows where it's going to go from there.
So, thanks for that. If,
Technically, our public hearing is continued at this point.
see.
I'll let you make a brief comment if you'd like, just keep it
Okay.
really brief.
I will keep it brief. If something were to happen with our system between our house and the street, we own that.
Like most other homeowners would
Right.
get it.
But once it goes to the street, what are you saying in terms of responsibility?
That I can't say,
Okay.
but it's the sewer department, it sounds like they're saying they don't want to take responsibility until it leaves the subdivision.
And as the planning board, we really shouldn't be stepping too far into that, but thank you for clarifying. And I'm sure there'll be more back and forth about this with water and sewer and Jeff Hills. Yeah, Rebecca?
I was just saying, it's my understanding, so we're talking about septic, I mean, sewer, not septic, just to make sure that's clear, and
Thank you.
that, the issue is that the Water and Sewer District has not adopted the system through the subdivision, and that's the
Yeah.
issue at hand.
Thank you, Rebecca.
All right. Thank you again for coming. So, yeah, so we are going to continue for a month till March 16th, and we'll see before then how much information we get from the applicant and where we stand.
That's all right.
I believe you're in a butter, yes?
I'm not sure about Mike, because too much snow melted today, so I don't want him to switch. Just for the board's edification, I added a few tiny things to this, so I'd like to
Okay.
pass out the prints prior to you accepting
Okay.
or denying the application.
So of course, you're welcome to introduce the boundary line adjustment, and of course, introduce yourself as well to the board and members of the public.
Thank you. My name's Al Bond, I'm the land surveyor, and related to half the people in the audience, so actually, Jack's, he is my cousin, he's, John's my second cousin, I'm doing this as all family stuff, and I got this traced back to when this was Holland's location back in 1700s, if you want to know, so that's another story for another day. But again, I'm Alan Bond, the land surveyor, representing the Francis family. And John Francis is here tonight as well in the audience. And we're presenting a boundary line adjustment. And just to clarify the notice, because this notice, one of the abutters found confusing. The notice should have stated we're doing the boundary line adjustment to obtain road frontage on Thompson Farm Lane instead of access. We already have approved access right of way from Thompson Farm Lane into this, also on a previously signed plan map that's at the Registry of Deeds as well. What came into play with this while we're doing this is the building permit statute. We want the frontage on the private road, so it makes it easier to go through that process. So that's what this is all about.
Can you just give us a quick heads up before we get too far?
Yes.
About what is different between this and this?
Well, for one thing I've added the suggested note in regards to the statute.
Okay.
That's the major thing.
Okay.
Made a couple tweaks to some of the lines to make it clearer to see. And I might have even put another description on a corner since I originally did it, but I'm not 100% sure. The main thing is the additional statement in regards to the 674 block.
Correct, thank you.
Okay?
Yep.
I wanted to get that off before, because I know if I didn't satisfy that suggestion, but it's a good suggestion. But I've added that, that's the main thing. Okay?
Is there anything else you'd like to present to us, or?
Well, I didn't know if you want to do the application first, and then I'll do an actual presentation, or would you like the full presentation prior to the application acceptance?
You can,
Keep going?
I would say you can give us a presentation now, yes.
Okay. Well, a boundary line adjustment, the same rules are a little bit different, obviously, because it's technically not a subdivision, it's a boundary line adjustment, meaning that there's no new owners and no new lots. So what this is I have a blow up in the lower right-hand corner of the actual adjustment we're doing, which you can see with that red circle, because we're adding 11,755 square feet, or 0.27 acres, from tax map block 203 lot 4 to tax map 203 lot 5. And also that gives a road frontage on Thompson Farm Lane of 183.06 feet, which is obviously well over the required distance for road frontage. Actually, we can, I believe, we go down 50 for the so-called Frank Hale type lot, but we wanted to have the full frontage. And actually, across the road here, on that corner, sharp corner, because this might come up as comment from one of the others who knows, is what we call the quarry. And that's the old quarry in there. I do show the existing road, which I call an existing road, which accessed this from Thompson Farm Lane, which we're incorporating into the lot. And this is what we call the Barney lot, just to let you know, the 203-5. And that was severed back in the 1800s when the old railroad grade went through there, and then that's why this right-of-way was created originally over the railroad crossing and all that stuff. But that being said, that's the purpose of this. John Francis had put it on the market, and there was, I feel, there was some miscommunication or some complications with people asking the town if they could get a building permit for this lot, and they said, it doesn't look good, you could get a building permit. And I don't think that was true, but this is the easiest way out of it, okay, is to actually give it the frontage on Thompson Farm Lane That was the purpose of the note that I just mentioned. Number 3, I modified that to actually protect my client and the town, because it said Thompson Farm, well, the land is a private road, and any building permit must comply with the process of the New Hampshire RSA 674-41, as it exists now or amended in the future in conjunction with the town ordinance and regulations, as adopted or amended by the town for a building permit application, when the application's applied for. The reason I said that is because that statute has been modified several times over the years. And also, even in the town regulations themselves, one of the last ones you did actually said a very similar thing to that, stating as the statute exists at the time. So this way, if it's modified, amended, or whatever, actually, there's some talk that being modified again because of this terminology. It really ran into the problem on islands, for instance. And they have to, we don't have to worry about that, but obviously, when it's talking especially, they say nobody can build on an island anymore. Well, that got rectified through other processes. But, so this statute is a good chance it's going to be changed again. So I added that extra terminology to protect my client as well as the town, to get it to leeway. Because what happens if we didn't, it would be, if it's approved exactly as that language was. And that means that if it didn't have that language then I've seen it overturned, say you have to come back through it. So that's why I added the extra terminology. I did bring a tax map, which I'll hand over here by Mike, he can pass it around. I highlighted the lot we're doing just to give you an idea of the overall area.
I think we've got one. Got that.
The other unique history, okay, you already had it. The other unique history on Thompson Farm Lane is the access from Quincy Road. It was actually challenged years ago because it went through another yard and people named Utile filed to shut it off. And there was a lawsuit at that time, and it was settled, and all the people involved out on Loon Lake were involved in that lawsuit. And this Barney lot was involved in it at the time as well for the access. So it was well established then. The survey had been recorded in the past of the Barney lot with the town stating that it wasn't under their jurisdiction and everything was fine to record, which it was. And but now we're here to adjust it to help conform to the statute and the town's regs. And it's going to be well advertised, hopefully, with the realtors, because you can't guarantee what a realtor will check off for a box. The developer's not, or the seller is not responsible for what a realtor does. But that being said, at least that is one of the reasons I know, when I was here and met with the planners here, why they wanted that terminology on the plan. So all the corners are set and the lines are marked at this time. So we're ready to go, obviously, for the board to review it and hopefully find it in favor to approve. If you have any questions, I'll try to address them as we go.
Okay, thank you. And it sounds like you know the process. You accept it first and then approval, and
I was planning board chair for 9
Yeah.
years. And I've only done this for 40-something now, so yes, I understand.
yeah.
Thank you.
Just formality.
That's fine. I appreciate it.
I make a motion that we accept the application, boundary line adjustment as complete.
Second.
Is there further discussion?
Yes. I just think it's good practice for us to be looking at all the requested waivers that are in the application. To me, it's really straightforward, unless there's immediate planned development for either of these lots, which my guess is there isn't.
No, there is no plans on any development or building. It's just to be put up for sale.
But I think it's just good practice for us to talk waivers
I agree.
as we go through this. But it all seems reasonable based on the fact that this is a pretty simple application and it's a boundary line adjustment.
Any
I'll be
other?
glad to address the waivers as you go through them if you want.
I don't need you to. They seem reasonable to me. So yeah.
Thank you very much.
Any further discussion? Okay, so we have a motion and a second to accept the application as complete. All in favor? Aye.
Aye.
Opposed? Abstentions? Okay, the application is accepted as complete. So now to get on to approval issues. Do we have any questions or concerns?
I did notice that there's no listed owner for the railroad right of way.
I was just looking at that.
That caught my eye.
Yeah.
Correct.
Okay,
I disagree with the tax man. I know he's in the audience.
I see. Thank you.
Title work was done, there was a lawsuit over that railroad grade and the right-of-way for public service. As a matter of fact, just to let you know, the utility company was notified as part of this, because technically we're supposed to notify utility companies, especially in this situation, because of the amount of the right-of-way. So I believe that the so-called bounty lot does terminate at the northerly edge of this, but there is some questions on the title of that section of the railroad grade.
Okay.
But we're not claiming it, so. At least at this time.
And your claim that the owner is in the audience presumes that they're aware of this
The listed
hearing.
owner on the tax map is in the audience.
Okay.
Where is he? We only got one of
Oh,
them.
got it. I see.
It's you and yours.
Okay.
On the tax map, Neil's on the tax map. He can speak on that if he so desires. I don't want to put words in his mouth. I can't put words in Neil's mouth. His father got me to this point now because he used to be my doctor, so he tells me I always have to behave.
I was just, my main concern was just that if there were an abutter that hadn't been noticed, that this hearing.
Technical listed abutter under the town is MacGyver, so they've been noticed.
Okay.
Yeah. So, and that's what we have to do legally, is we have to notify what's on record with the town, which they have done.
And Neil is here too.
Correct. He stepped down, see, he was so nervous about this. He's not nervous, believe me.
I do want to remind the board that we are obligated to do a findings of fact
All right.
as of,
That's new.
yeah, exactly, yeah. This year. We even have a nice sheet for it.
Sometimes the zoning board does, list them one at a time and, has some sheets that they use. So made that available if the board were so inclined to want to write out the findings of fact as you go through. Obviously, it's,
For
might
example,
be,
required frontage is met for the ag zone.
it's a great example.
I write that down.
Well, we should make them verbally as well. Right? Is that the process?
Oh, yes.
I'm new to this.
Yes, no,
It's so confusing.
typically the zoning board will, they've been required to do findings of fact for some time, so they will typically, a member will propose a fact, the board can discuss it, and if everybody sort of concurs with the fact or the majority agree, they just write down the fact, and then it's, so listed in the minutes and the records. It can be, your example was a great one, the frontage is, in excess of what's required.
Is this something we want to talk through now or after a public hearing?
Um,
Or just all the time?
That was just a reminder, and I gave an example, but probably should open a public hearing before going much further. So it is currently 7:09, and I will open a public hearing. If you would like to speak, please come up to the podium and identify yourself. Yes?
I'm Neil McIver. I'm in a butter to this piece of property. Leslie Kellenbeck and I jointly own the lot that's listed as number 6. It was formerly known as the Huzzy lot. It was subdivided long ago, I think. The access to this lot has been by a farm road, which comes off Thompson Farm Road, in the area that Alan has described, and goes to Quincy Road. And when I was younger, I recall that Mr. Huzzy had a gate across the road, and you had to open the gate when you wanted to go up the road, because he had cows, and he had a night pasture, and the cows would walk across the road. And before him, I think it was the Gibson property. Anyways, it went way back, and in our deed, it references this farm road that goes from Thompson Farm Road to our piece of land. And I have intermittently and occasionally used this road over 40 years, and I just want it to be recognized that we have this road to access our land. I have no objection. I don't see how this subdivision plan can hurt our interests in any way.
Thank you, Neil.
Hi, I'm Jeremy Thompson of 21 Thompson Farm Lane. My interest in this subdivision is that I'm the first house off of Quincy Road on Thompson Farm Lane. So my house is the road that fronts Quincy Road, and then Thompson Farm Lane is a right-of-way through my property. So any activity on this, on the subject properties are going to impact my property, not beside as an abutter, but right through my property. So I do have an interest in what's going on back there. So first of all, I'd like to thank the planning board for your time to the town. I appreciate you giving me the time to talk here. And I'd like to also acknowledge my neighbors who are the applicants, who are good neighbors and they're good stewards of their land, and they appear to be doing the best for their family's property, same as I would. So let me talk about Thompson Farm Lane, which is the thrust of my interest here. So it's about a 5,000-foot long easement right away. Access is 7 cottages on or near Loon Lake and some farmland. And it passes through 3, maybe 4, as we spoke to earlier, private properties before it reaches the subject properties. It's mostly not defined by meets, bounds, or widths, or monuments, but by rough sketches on plats, loose language, and a lot of deeds, and as was mentioned before, a Superior Court order which assigns some rights to some different people. So I'd like to provide an example of exactly how Thompson Farm Lane is legally defined. And Lot 203-5, which is one of the subject lots, defines Thompson Farm Lane as near the easterly boundary and extends in a general northeast and northwest direction. So and that's a pretty tough direction to follow there. But that's how Thompson Farm Lane is defined. So that's a little bit of flavor of Thompson Farm Lane. So I'd like to let you know what my concerns is for a subdivision on Thompson Farm Lane. So currently, lot 203-5 has a for sale sign up in front of it. And it looks like the sellers are looking to attract a developer. 203-5 is 26 acres. So it's a 26-acre parcel, so it could entertain some significant plans. I'm concerned that one day I'll come home and I'm going to find a bulldozer in my backyard, and the developer's going to hop off and say, I got to straighten the road. And I'm going to say, well, the right-of-way is over there. And he's going to tell me, no, I'm just going in the northeasterly and northwesterly direction. I'm fine. So who's going to help me get that bulldozer out of my backyard? So the town won't, because it's a private road, right? And you're not going to get involved with that. So I'm going to be stuck holding the bag, and my dwindling bank account is going to be working to try to get that bulldozer out of my backyard. So that's my concern. And I'd like to talk about a few applicable subdivision regulations. So, Town of Plymouth, subdivision regulation, Article 3, Section 3, common terms. And I'm quote, "A lot line adjustment means a subdivision." So we've talked about before, this is just a lot line adjustment. This is a subdivision, as, according to our zoning ordinance. Article 8, Section J2, streets. Let me read that for you. All streets in any future subdivision shall meet the minimum standards set forth in this section. The applicant shall bear the responsibility for improving to such minimum standards any and all connecting streets if not publicly maintained. This subdivision does not meet that requirement. Section J4, streets, right-of-way. All street right-of-way widths shall be a minimum of 50 feet. This subdivision does not meet that requirement. Section J5, curves, doesn't meet. Section J8, construction standards, and I can name a few more. But just let me summarize here. So I'm a strong believer in private property rights and the applicant's right to do with it as they choose to the extent that it does not negatively impact my property. This subdivision is a step in developing a back lot that will have negative impact on my property. It does not meet the physical requirements of our zoning ordinance, and I ask the board to disapprove this application on its merits.
Thank you.
John, which lot? Can you show us where his house is?
Can you clarify, please?
Yes.
Is this, are you 9?
I am
Five.
So the rail,
5.
5.
Yep.
And there's no house on 4 or 9?
There is a house on 4, and there is a house on 9. That's kind of close together for you. So there's two private rights of way, right side by side, Thompson Farm Lane and Lewis Lane. So Thompson Farm Lane goes through 5, takes a hard left and then a hard right. Yeah, that's it.
And goes across the train tracks?
Yes.
There's also a house on 7. And a house on 8.
And
According to the tax map. If you don't mind. I presume that's correct?
7, yes, and I didn't see 8. Let me,
Well, I'm looking at, what is it?
it's-
Those are both
eight,
off
yes,
Lewis
8,
Drive.
yes, also, that's correct. But 8 is not on Thompson Farm Lane, it's
Off
accessed
Lewis.
by Lewis.
Yeah.
How about
7 access from this road?
No, 7 is accessed by
From
Lewis, by Lewis Lane.
That's Lewis Lane?
Yes,
Basically a common driveway.
that's right.
Yeah.
So
Which
between
this
my
is.
house on Quincy Road and then the next house, it's all the way up to almost Loon Lake. It's 3/4 of a mile, maybe.
Thank you. Are there further comments? Yes?
My name is Stephen DeCosta, and I'm the owner of 6.1 acres in Plymouth, which is adjacent to Thompson Farm Lane. My land has been landlocked, and I can't get a permit to put an easement on my own property from Rumney side, and Thompson Farm Lane is beyond my reach, according to John Francis and others. And so I'm landlocked, and I can't do anything about it. But I did check, and it turns out that part of Thompson Lane goes through a corner of my property, and I can't use it. And I understand from talking to the planning board in the past that it has to be a 50-foot easement or a 50-foot road going in for public safety, which fire engines or whatever, and emergency vehicles. And that's what I've been told. And there's no such a thing as a 50-foot right-of-way that I can see. Now, I have a copy of 3 different deeds myself, and Dutile and Lyford. And on all 3 deeds, there's no indication of exactly the boundaries of Thompson Farm Lane or the width of Thompson Farm Lane. So it seems to me that we would have to actually put that on the deed to make it legitimate. And I don't see any of that in anything. And I was out there today and I took a measurement, a few things. And Thompson Farm Lane has recently been re-gravelled, I believe, back in November. John can tell you more about that than I can. But I took a look at it, and that's no more than 10 feet. That's all it's showing. It's all fresh gravel. Now, I put an eye-line sight down from the boundary marker right down along my property line, and on the right side, there's a section where it used to be a stone marker, boundary marker, and it's nowhere to be found. It's missing. And in the process of that, there's a lot of debris and junk and piles on my land and on the other land, right in the same area. I took pictures of all this. And I'm just concerned that I'd like to be able to, why I'm here is to hopefully to find a way that I can at least sell my land and use Thompson Farm Lane as an access. And I know public service for telephone use has to have 50 feet of road to cross over land. That's what I was understanding from talking to public service people about putting power in. So basically, the two things I need access to my own land, which I don't have, and I need to be able to access the public service so I can service it and sell it. And right now, I can't do a thing.
Can you show us where?
Yeah,
Parcel 6,
if you'd like to point to that.
tax map.
On the different deeds and on the maps they show, there's a fellow named Paul DeCosta. Does not exist. I'm Stephen. That's the land I own. So somehow they got a misprint there. And my wife Joanne, so myself and my wife Joanne that own the 6.1 acres, which is adjacent to Thompson Farm Lane on the south side of the railroad bed. Is there any questions that somebody would like to ask?
Not from me. All right, thank you very much.
All right, well, I didn't want to leave people up in the air, so I took a flash drive and several pictures of the land, the road, and different things about the road and the boundaries and the deeds. It's all on here. A flash drive.
Here, Joseph.
Okay?
So Joseph, you're going to load down a computer or something, I guess? Would you like us to look at these, or I'm not even sure we can do that at this point?
My
but-
guess, that's why I put it for us, you guys can take a look at it and see what they're talking about. 50-foot width of a road seems very necessary if you want to use fire trucks and emergency vehicles and things like that.
There's also a difference between the actual road itself and the right-of-way.
The road, Thompson Farm Lane right now, I think with Mr. Thompson, he had 50 feet in front of his house. How far that 50 feet goes back, I don't know. But right now, there's only about 10 or 12 feet of actual road that can be used, that's gravelled and redone. And it doesn't show the boundaries of where it is or the width, anywhere in the deeds. And if you're going to do some adjustments on these things, I should think that that would be very important to have that on the deeds.
Yes, Mike?
Where's the point that you said that was on your property that you can't find anymore?
It's in the northwest corner,
Northwest or northeast?
right there.
That's the lot,
Yeah,
the corner you
and-
can't find?
Yeah, and, no.
No.
What's missing down here is when this land here comes over here on the bottom 6, this corner right here, there's a
If we,
stone marker that's disappeared.
That's the one that's disappeared.
if we can point to that so we can all see it.
Somebody get rid of it.
This is the one that's disappeared.
Somebody get rid of it. I don't know why it's not
Okay.
there. It's
Thank
on
you.
the deed, it's not there.
And it used to be there.
As far as I know it was, it's on the deed. I don't know what happened to it, no idea. Because it's not on the deed, it seems like trash is getting thrown out. Well, basically, I'm just hoping that the planning board will find some way that we can at least get access to my property so I can at least sell it. And as the town of Plymouth is concerned, one house is fine with me. I wouldn't want a whole bunch out there. But at least one house would be some tax income for the town.
Thank you.
Thank
One
you.
other question?
Yes, Mike?
Yes.
So this roadway goes along your property here?
Yeah.
But there's no way that you can access from anywhere along this stretch?
Well, that's what I'm told. I don't know why. Because there's nothing on the deeds that show the actual boundaries and measurements by feet or 50 feet wide, exactly where the start and finish is.
But you see the roadway, so you can actually get to your property through this, correct?
Oh, I can't put a driveway in, can
Well, it just,
I? I have no access.
I mean, for this evening, I think the condition of the road is an appropriate part of this discussion. Your access to your land is a somewhat side issue to this, except insofar as the documentation of this road might be an issue.
I just wanted to bring it to attention and put it on the record, that's all.
Thank you. Peter, do you have a comment?
Does the, oh, actually, it's kind of to Al. You note on your plan references a Superior Court case.
Actually, I'd like to reserve any answers until we have time for rebuttal for all these others, if it's all right with you, Pete.
That's fine.
Yep. But I'd be glad to address those at my rebuttal time. Is that okay?
Yeah.
That way we can consolidate all this at once. I know you'll have a good question.
Are there further comments from members of the public?
I'm all set?
Yeah, thank you.
Just one more comment. So Mr. DeCosta just mentioned 50 feet on my lot. So I have 50 feet of fee simple property, which is my frontage on Quincy Road. That is not tied to the right-of-way. So the right-of-way is not 50 feet. The property I own is 50 feet. I just wanted to clarify that. Thank you.
Are there further comments?
I might like
Yeah.
to say something.
Please come up.
I'm Jack Francis. I've been out at summer property out at Loon Lake for over 70 years now. And what I would say to Mr. DeCosta is, why can't you have access to your lot you're trying to sell off the Quincy Road, which you already did on a lot you sold? Then there wouldn't be all this problem, because we don't want a lot of people using our road.
The Department of Transportation says I cannot put another driveway. If they stop me,
All right?
they wouldn't allow it, I have no chance.
And I wish there was a woman here named Mrs. Lyford who has a home on Thompson, well, actually it's Lewis. And when you were selling the land, it was advertised falsely, indicating that anybody who bought the lot, what is it, 8 acres? How much is it?
6.1
Pardon me?
6.1 acres.
6.1 acres with access on Thompson Farm Lane, which is not true. If Mrs. Lyford was here, I don't want to speak in her behalf, but she had a hard time. She wanted the signs removed off the tree because people were going down Thompson Farm Lane onto the railroad bed to look at the property. But she has, and I'm not positive of this, Alan might know, she told me there's like 9 or 10 feet off the road to an old barbed wire fence. There's still some posts there. So as you're saying, I'm not absolutely positive of the width of the road, but she has 9 or 10 feet, and she'd have to grant a variance over that for somebody to access, to get in that lot. If he doesn't have permission to put a road in off Quincy Road.
I don't want to go too far off
Okay.
onto access to the other lot, which is
Well,
another issue.
it's a big issue because we spend a lot of money taking care of our own private road. The town wants nothing to do with it, so that would mean more and more traffic also for Mr. Thompson. Like you said, bulldozers and a lot of equipment going in there from Mr. DeCosta's land.
Thank you.
So it's a serious issue.
Actually,
Thank you.
there's 3 flag lots in a row, 5, 7, 8. Bang, bang,
Are
bang.
there further comments from members of the public? Or online? I see only a few people left there, I guess, or if any.
One person left online, not sure if they want to speak.
Are there any comments from anyone online? You can unmute yourself if you do. Okay. And other members of the public?
Would you like to let the.
Actually,
applicant
I was just asking myself this question,
The issues.
because there might be further discussion after you speak to these issues. So before we close,
Good idea to leave it open.
yeah, I was just kind of going through that in my mind, thinking about this. So would you like to speak to some of these issues?
Well, of course we will.
First of all, it still is not a subdivision. The definition, it doesn't meet the state statute definition of subdivision. These are two existing lots, and this is just adjusting one lot to get frontage on Thompson Farm Lane to make it easier to obtain it. There's no increase and no change of the use of Thompson Farm Lane. That doesn't even come into play here, because we already have a right-of-way and access over Thompson Farm Lane into this lot. Mr. DeCosta is correct, a little corner of that Thompson Farm Lane goes across his property, but some of his issues was created in Rumney, and that is a civil issue, which is not something the board wants to get into. And as well as to address Neil MacGyver's pointed out, we've done some title work and stuff on that. There's still some question on the validity of his use of that right-of-way and that sort of thing. We have not challenged it from either direction, but if you noticed on the map, I have located the entire road going through it and show it going into his property, so it is depicted, and that is going to be that's a civil issue between the two owners, so we have not shown anything incorrectly there. The piece that goes across to the Costa land is on 203 Lot 4, and we're taking a little piece of 20304 and adding it onto the lot we're doing now, 2035. So that's the reason why they were notified, was because of, we notified everybody around both parcels. But again, the thing to keep in mind, the width doesn't come into play. This is not a subdivision. Any of the improvements doesn't come into play. The use of the road is going to be exactly the same. If this is approved or not, that access is going to exist, and they'll come to the town for a building permit over the right-of-way, because we're going to call it a road anyhow. So keep that in mind when you're trying to consolidate your concerns and input from the public in regards to that. This does not solve any traffic by the other Mr. Thompson, doesn't solve any issues of access to the DeCosta property. This is just to get the frontage onto a private road, and it's going to be the same amount of functionality of the road and access, regardless if this is approved or not. So dragging in all the requirements for a subdivision is not applicable here. As a matter of fact, that's pretty much covered in the waivers, which are already approved. And it is a boundary line adjustment, which is no new owners, no new lots created. And this does not constitute somebody attracting a developer, because I can tell you right now, as you well know, they've stated it very well. Yes, you would have to have a 50-foot right-of-way. You'd have to do a complete engineering study, and also this Thompson Farm Lane doesn't even nearly meet the road curve requirements. There's no way you're going to subdivide this property and meet it for a subdivision. We're just trying to do it for frontage on Thompson Farm Lane to meet the private road standard, to sign so we can get the a building permit approved easier for the release of the liability to the town. They might not be aware, but you also have to sign on a Class 6 road as well as a private road, a release of liability waiver release with the town, which that has to go through the planning board and the selectmen as well, to release the town of any liability, such as fire protection, ambulance protection, and all that items, to build on this anyhow. So I think that pretty much addresses it. But Mr. Julia had a question, and I'd be glad to try to address that one now, if you may.
Peter?
Mr. Chair, I should have gone through you, I'm sorry.
Peter?
Yeah, so the court case, is it, I mean, did you include an excerpt or any part of that with the application?
No.
Why not?
Didn't feel it was necessary because we have access.
Well, it seems to define the right-of-way and the use by others. So I'm kind of wondering, in that court case, I'm surprised it uses the term right-of-way, because it's not a right-of-way. It's more of an easement for ingress and egress. So I'd be curious what that language says in terms of how this private drive is classified and described, and what use and by whom, defined by map, lot, parcel, you know what I mean?
Well, it wouldn't be defined by map, lot, and parcel, and again, it's not the board's, I don't believe it's the planning board's, should get involved in making any interpretations of any legal decisions that have been made in the past. Thompson Farm Lane, where it exists now, was created from the results of that court case. Matter of fact, I was involved in the Dutile case back in the 80s when that was originally done. This was put on the ground and agreed on to by the court that all these parcels that we're showing right now, and including the one we're accessing into, had access over it, except for the DaCosta property, because that did not have access, even though it might go through a corner of his property, does not have the rights from that point out to Quincy Road. But again, that's not germane to the decision of a boundary line adjustment in regard to this. So, I mean, I don't feel it's necessary to bring that forth to the board, because if you don't agree with what that case says, I don't think you have the jurisdiction to interpret that.
No, don't. Of course not. I just want to know what it said in terms of...
It says these people have the right to use that road, and that's why it was constructed, so I think that's what we have to go on. As a matter of fact, it's been taxed that way since that point as well. The town has charged taxes for the right-of-way to this lot, as well as to all the access for Thompson Farm Lane, except for the Rumney parcels, of course, is being taxed in Rumney. That might not be the answer you want to hear, but let's say that's the one I gave you. So.
Understood.
Okay.
Thank you.
Any further? Yes. Yes.
Should I stand over there?
Yes, please.
Are we going to be limited to rebuttals and to
At this point, please keep any comments to 3 minutes, and
Yes, no problem. So just one comment is that here we are in the town of Plymouth, the town of Plymouth Planning Board. I'm looking at the subdivision regulations for the town of Plymouth. The subdivision regulations for the town of Plymouth call a lot line adjustment a subdivision which exchanges land among owners and does not create a buildable lot. Looks like we're trying to create a buildable lot here. According to the town of Plymouth, this is subdivision, and I'd like to cite the ordinances that we live by here in the town of Plymouth. That's number one. My second point is that we're trying to put frontage on Thompson Farm Lane. Well, where is it? How do you put frontage on something that doesn't exist in a certain location? So he can draw a line on his map, and they could move the road 50 feet to the left. It doesn't really exist in any certain place. And they could do that on the properties that are the subject properties, but there's many properties that are off of their subject properties. So for instance, I don't think they could come onto the other people's lands and draw meets and bounds and say, this is where Thompson Farm Lane exists.
thank you. Does anyone else have anything new to present? Yeah, Neil?
I'd just like to reiterate that our deed references our road, and if we didn't have this road, our land would be landlocked. I've used this road for over 40 years, and I know that our previous owner, Mr. Huzzy, who owned most of the land in the area along Thompson Farm Road, used the road himself to access the land. It's a farm road. Previous owner of the Barney lot, Tom Roy, told me that the road was 1 rod wide, but I don't have any proof of that.
Thank you. Any further comments or new information to?
just one last conclusion for the applicant, usually appropriate?
Yeah, you may.
I'll leave it, so hopefully, just to basically not contradict anything. As far as Neil goes, again, we showed it all the way through it. We've had Attorney Brian Ray research it. He has not found this right away that Neil has talked about. I have asked Neil to produce it for me. We're still open to deal with that. Again, My client's not saying no to him. If he was, he would have blocked it off, and that's not the case. And we just wanted to get it on writing in regards to that. And again, for the board, I object that if you took it as a subdivision, even though it says it falls under the subdivision regulations, because that's the only place in the New Hampshire statutes that allow for the planning board to review a boundary line adjustment. In the statutes themselves have no place whatsoever for a boundary line adjustment, so it has to fall under the subdivision regulations. But a boundary line adjustment is not a subdivision, and this is a buildable lot, regardless if we do this subdivision or not. I mean, boundary line adjustment. See, you've already got me confused on that. And so we would be back, this is a buildable lot. We're not creating a buildable lot. So just to answer those last questions, I still would like the board to act on the adjustment as we did. And yes, we defined the edge of Thompson Farm Lane for this property line. And in this case where that is not a defined width, it's usually the used width anyways. And we're well outside of the used width to make sure that we didn't interfere with anybody else's rights in regards to use of Thompson Farm Lane. All right, and I think that covers everything that we've been talking about. I appreciate the time of the board. Thank you.
Thank you. Okay, it is currently 7:41, and I will close the public hearing. So, members of the board, how we wish to proceed?
I have a couple things. So when we talk about frontage, this might be a dumb question, but I'm, flipping through the zoning ordinance and the subdivision regs. And I agree that a boundary line adjustment is different than a subdivision, but we manage it like a subdivision in our system. There's no public road frontage on either of these lots as they exist before a boundary line adjustment. Right? Okay.
Just one line, so. The other lot, all of Thompson Farm Lane.
The Thompson Farm Lane is not a public road. Right?
No, but building permits, public or private.
Right.
Right.
Okay.
Your point is that neither lot 203-4 nor 203-5 have frontage on a public road.
Right. And lot 5, from what I'm understanding, already has access through lot 4. Am I understanding that correctly? That there's existing access.
Correct.
Right.
Over the road is shown, yes.
On the
It's
on the
better-
existing road. Okay.
It's better to look at the blow-up circle for that.
Yes. Thank you. It's such an improvement based on the tabloid size that I've been looking at already, so. All right, I'm just processing through this, so just bear with me here. So for Neil's lot that he co-owns, it's currently, the way it's written, it goes through 2 pieces of property. As the boundary, if this goes through, then it'll just be one property owner, one lot that it's going through.
Mm-hmm.
Okay. So if there's access granted through, I mean, it should carry, I would imagine it would carry through to, I mean, there's no change in ownership.
There's no change in access.
Yeah, hang on. All right. Those are kind of my points, I think.
I'm not sure if you're going here or not. I was wondering if you're asking the question perhaps, if we already have a buildable lot, what is the benefit of the frontage on Thompson Farm Lane?
It was suggested by the planning department to make it easier to obtain the building permit.
Okay,
That's why we're here.
fair enough.
So in the, do you mind if I keep going?
No, go ahead.
Because I realize there's more. In the event that we're going to throw in, it's the ag zone, so 1 acre minimum. Don't be scared. I'm just working through the process here. There's a whole issue of road access that our subdivision regulations for a major subdivision are intended, aged as they may be, are intended to make sure that there is adequate access to any major subdivision. Now, I don't really like to kick cans down the road to deal with at a later date. I just don't think on a boundary line adjustment, which is even less than a minor subdivision, is the time to really think about how these lots would be accessed in the event of a bigger subdivision.
And in fact, if a major subdivision was to hypothetically happen here, then the road would absolutely come into play. And that's kind of what we're getting at here, I guess, then?
Yeah.
So I mean, if, in the event that that happened, then the question of the road would be reopened in a different context than it is now, and with different standards, perhaps. Maybe.
Maybe some modern adjustments to our 21-year-old subdivision regulations.
Any other thoughts or questions from the board? Mike?
I don't know if it was Neil or someone mentioned that there were gates or bars at some point on the road. I didn't know where that's
That's the Quincy Road area. And actually, that is nowhere near on this. That's if you don't mind me answering.
You may, go ahead.
I didn't mean to jump in there. I
Fine.
was trying to clarify his question. You talked to Huzzy Place, that's the gate where it went through Dutiles, which caused the lawsuit to have Thompson Farm Lane relocated. So that gate is not,
Oh, here.
it's not even germane to this. It doesn't even have access to it anymore or anything.
The gate was,
The gate was towards Romney side on the town line.
was here.
No, it was over here.
Oh, okay.
Like I said, nowhere near any of this. Remember, this is all, well, to me, this is all new.
Okay.
In the 80s, to me, that's still new. And again, Thompson Farm Lane was a result of the lawsuit put in to set for the access because of that gate issue that we're talking.
Well, should we perhaps let's go through what we'd have to meet as requirements, and that could be our findings of fact, and see if we meet those requirements. We established already the frontage issue, and I know you've taken some notes, and others perhaps have as well. In order for this to pass, like, what are our requirements, and do we meet those as findings of fact?
I have one more question.
Yes, Mike?
Clarification. How does lots over towards Rumney, how does lots 1, 2, and 3? I see 19 gets access by another road, but 1, 2, and 3, does that come off of Thompson Farm Lane? Or are there houses there? I'm looking at,
Well, now, some of it comes in off of Loon Lake.
so it continues on to access 3,
2
2,
and 3,
1.
yes, 2 and 3
2 and
goes.
3.
Yeah, 2 and 3. 1, 2, and 3 come off of Thompson Farm Lane, which were part of the lawsuit to get their access out there.
So they still have access over this road?
Correct.
But they're not really using it, they come off of here, is what you're
Well, they
saying.
use one. Everybody, again, any of the access points and the people that use the road, nothing's changed. And nothing's being changed. All the access is staying exactly as it exists now, regardless of the number.
So finding of fact is a lot line adjustment does not create any new lots, new number of lots than what already exists.
Okay.
That's accurate.
Unless there's any objections.
Another one would be what's the lot that's giving away? What's
4.
that?
4, 2034.
But there's a term.
The donor
The
lot.
giver, the donor lot, and the receiving lot,
The grantor and the grantee.
the grantor and the grantee will still be more than the minimum size.
Size, yes,
Size.
by a good amount.
44 acres.
there is an attempt by Lot 5 to become more conform.
More
with-
conforming.
More conforming, by having at least 100 feet,
180 feet of frontage on a
180
private
feet of
road.
frontage, some more conformity.
Which exceeds the 150.
Does that make it more conforming if if it already has access granted through the other lot?
Frontage on a private
It's-
road is
Yeah.
better than access via private road.
Maybe we could just say that it has, I mean, we had the original one, the first thing that was mentioned was required frontage for the ag zone. I mean, is that? I don't know if it's more conforming with the access already there. I don't have.
Well, it goes from a right-of-way over someone's property to actually owning the land.
I don't really have an objection either way. It's fine.
It would, I interject just
You may.
to help clarify the definition. It was suggested by your planning department to do this, to make it more nearly conforming, so it would have frontage on an existing recognized private road compared to a right-of-way, which we stated was a road, and they said it was more like a driveway. So again, the planning department felt it was more nearly conforming by having the frontage on Thompson Farm Lane, which I think helps elaborate what you would.
Yeah, more fully recognized private road, yeah.
They felt it was more, so when we came for building permit, it felt it was that was the place.
So you were trying to pull a building permit for one of these lots, but there's no plan for immediate development? Or may I ask?
Not trying
May,
to
yeah,
pull it.
yeah.
We weren't trying to pull a building permit. It was when they had interested buyers.
Gotcha.
came
Okay,
to
thank you,
town.
thank you. Okay.
Right, they told them what they needed to go through, and this is how this came about.
Okay.
Sorry.
They didn't say no, they said it would be difficult, but if you did this, it meets our regs to apply.
Yes.
So more nearly conforming is a very good term.
I mean, not a whole lot else.
I mean, it's a lot line adjustment, so there's not that many findings of fact necessarily to, yes, Peter?
I have a question and kind of a comment.
Yes.
Since this application is real, it's accepted, it's here, it's now,
Yeah.
and the planning board has an opportunity to review all sorts of things. One of the things in my mind that I think I would like to at least entertain to the landowner and their agent is establishing, at least in language, perhaps not in meets and bounds, but at least in language, an agreement or by via a note on this plan that recognizes the right of access from Thompson Farm Lane to Lot 6.
That's Neil's.
Correct.
That's not gonna happen. That is in process now. We have an attorney that has not found that. It's not the board's gonna take that stance. You're stating that, you're saying that we have to give access, legal access and document it on the plan to Neil's lot, which is still under discussion, which is not the board's duty. That's a civil issue.
I could see sorry, go ahead.
I was gonna say, I can see that, if there's an encumbrance of, if they can document that there's historic use and, I mean, it would be a civil issue, I agree.
Historic use, as Neil mentioned, 40 years. He absolutely has an absolute perfect case for prescriptive use to that property if he can't document it to the satisfaction of my client or to his attorney. But that does not happen without litigation going through court or an agreement. And that's not the job of the planning board when we have a right-of-way into our lot now. And again, we're not trying to take that away from Neil. We just wanted to see it in writing, and that's why I showed the entire road again, through the lot, into his. We're not hiding that, we're reflecting it. The earlier survey just showed each end. I've located the entire thing. And I'm certainly not trying to take that away from Neil, and neither is John. He just would like to get that resolved, but that's not this board's responsibility. They're in that process. As a matter of fact, I've talked with Neil. He's talked with Brian Ray, attorney, and talked with John. So hopefully that will get resolved on our end.
I could see how it would be nice to have that included in the recorded paperwork here, but I also think that this lot line adjustment doesn't necessarily change that at all. It's still, it's one owner on that existing lot, so any.
And if there's no existing documentation of an encumbrance of, on lot 5 that benefits lot 6, I don't think it would make sense to require that on this plan.
So as a point of clarification,
Mm-hmm.
I didn't state it was a requirement. It was a question and put forth in good faith so that a landowner, should they choose to create formal documentation, again, in good faith, this would be the time to do so.
Thank you. Yeah.
The only point I was making.
So in the answer, the response to me seems that it's the property owner on lot, is this 5?
5.
5. Won't do so as a matter of good faith, and will only do so as if there's documentation that's uncovered that demonstrates that access is existing. That's what I'm understanding, so.
It's an ongoing process.
Yeah. So I shouldn't have said good faith. There was no judgment or any value in what I said.
Actually, there is good faith between John, Brian Ray, and myself and Neil. We're not trying to shut him out.
I think that, it's, you don't even need to respond. I just want to, just understanding that it's not something that's going to go into this.
Yes.
So.
Because we could easily put a note on there saying it doesn't go through. Just to be opposite.
Mm-hmm.
But we're not going to.
We have a few findings of fact. We probably do not need extensive findings of fact on a lot line adjustment unless a particular issue warrants it. How do we feel at this point as a board?
It's pretty straightforward what he's doing, and I'd be ready to make a motion. I make a motion that we approve the lot line adjustment with the 3 finding of facts that we have, and keep it as simple as possible.
Okay, so we have a motion and a second to approve this application. Is there any further discussion?
Do we need
I'm just looking through here for like potential conditions or anything.
yeah, that's what I was just going to say, that there was one that just, Mylar copy for that's pretty boilerplate that I think.
And the other ones are already on there as number 3 over here.
Yep.
Any further discussion? Okay. All in favor?
Aye.
Opposed? Abstentions? Okay. The application is approved. Congratulations.
Thank you. Here's your Mylar, and here's your checks.
All right.
You want
Thank you very much.
copies back, Alan?
Well, we'll leave all the copies here. You'll sign these at the end. I'll pick them up.
Usually not right at the end of the meeting, but yes.
Well, they're here.
I'll pick them up later.
Yeah.
Sorry, I put mine in upside down.
Does the Mylar also have a spelling error?
I did notice that.
What was that?
Thompson land, not lane. Yeah, I noticed that as well.
Yeah.
That was the longest boundary line adjustment I've ever sat through.
It's also the
Yeah.
most contested boundary line
Yeah.
adjustment
No,
we've
it's-
seen in a while. I've seen.
Never,
Ken.
you never know.
Well, it's his stamp. It's actually quite common. Engineers can't spell, and surveyors can't spell.
Thank you for
That's
your
why
level
we have,
of
that's why we have spell checks in our software. So it's supposed to read spell check. I love my bands.
No, I will say that
That can go away.
courses available to the abutters. Available to the property.
My deed specifically states that the right-of-way is referenced in a previous deed.
Obviously, you know what I meant on the other
It
side.
goes way back.
Liable for.
You go far enough back.
That planning ask for egregious things just because
All
they
right.
can. It's public.
I gotta put this on the wall.
I mean,
I could say,
Members
why don't you
of
put
the
that
board.
Downstairs on the wall, but you could have that one on your wall too.
Not done yet.
Well, I need things on
And
the
if
wall.
they really
Me too.
they would have no problem doing that. Correct it now and get it
Hello,
over
hello.
with.
Put them through the ringer.
Not done yet.
Here's whoever they sell it. Okay, it's done.
It was always my understanding,
never hit the two.
Okay.
we have two houses.
Next on our agenda, we have informational and pre-application reviews. And I believe we do have a
Conceptual?
conceptual from Rick Chase.
It's just the one, the only one I noted was on the note.
What's he saying?
We have a conceptual consultation with Rick Chase.
What's he representing?
Well, no, I'm a horrible speller, which is why I catch most other people. That's the only one I know about spell check with land. That has to do with the land.
Consultation.
That's yours.
That's my file, but it's on the agenda.
Mine's here on
Hey.
it.
Okay, we're going to continue with our meeting. If you'd like to stay, you may have a seat, or
Where is he located?
Hope that wasn't on television.
I have no idea. I'm not in control of the cameras. It's okay. Jace? Yes. Would like to come up? And so you have a conceptual consultation with us? Just to be
Yes.
clear up front to the board and to you and everyone else. So this is a non-binding conversation where we can clarify process and you can share your thoughts and your desires with us here, and
Ask questions.
ask questions. And if it does come to the point where you want to get something binding, of course, you go through I believe in this case, it'll be a subdivision
Okay,
process.
yes. Okay. My name's Rick Chase, and I have an agreement to buy a piece of land on Fairgrounds Road. It's 73 acres. And I'm looking to, if we go through with the purchase, to separate it into two lots, two 37 acre lots approximately. We're trying to split it right down the middle. And I'm just looking for a little, hopefully advice, what would work, what would be acceptable to the board as far as getting access to the two properties. If I could ask maybe one question right off the bat, I've noticed, is it possible to access two lots off of one driveway? Is that
Sure.
something you can answer to me?
There is a provision for shared driveway in the RSA's.
It has to be 25-foot width, right?
There are some specifics about,
What's the frontage on that lot?
does our zoning require, have
20.
any specific language about shared driveways or common driveways?
I didn't see anything,
Correct.
Oh, yeah.
but it's,
Gets to be.
Can I point that out to the applicant?
Peter, yeah?
Oh, I'm sorry, I just asked, selfishly, he's got the computer right here, right? This lot, lot 20, correct?
Correct.
Right? So
Can you highlight it?
you have two access ways. Well,
Yes.
that lot does, not
Yes.
you, but it has a 50-foot right-of-way, which you
Oh.
can see highlighted, and then it has actual frontage on Fairgrounds Road.
Correct.
Where's it located?
One driveway one driveway the other.
Okay, good.
Two off one, I mean,
Okay, that's just what we're trying to make sure before we pull the trigger.
because it obviously, I guess it has 119 feet on fairgrounds, and it would require 200 to have two separate lots, if I understand it right, but we just want to make sure that,
The second lot would need frontage. I think if you're talking about Welch Drive,
You'd subdivide the line right down the middle.
yes, Welch Drive appears to go dead end at the property line. So that was one question, could we bring a driveway in off of that to one lot? Because our intent when we separate it in half is just split it in the middle and end up with the same amount on both sides of the lot, the middle lot line.
here.
Again, I serve on the zoning board, so
perfect.
if you needed a variance or waiver, without seeing the topography, and I haven't walked out there, but I know where that land is, where, if you can see the image, where the big, what is that, your cursor or the information blob is? Yeah, because of that body of water, there's likely certain environmental restrictions with that.
Yep.
So that, if you had a consultant that was advising you, they'd probably advise you to go that direction, which would be a legitimate hardship to gain access through the right-of-way and then a separate one that way. As long as your desired buildable area or the area, land you're trying to access is either ahead of that water or clearly to, if planned north or straight up or to the east. In other words, you can get around it.
Yes.
If you cannot, then that's a whole nother ballgame.
Yes, from scaling it off the plans, it appears there's 100 feet between the lot line there and the water. So,
But is it dry upland land?
yes, the pond is down, I would say like 15 feet.
Is
Okay.
there a NWI or a designated wetland layer in there?
There is a layer.
Gotta be, yeah.
It's not on
Yeah, it's not on it, but.
the, I mean, the aerial, the topography actually looks like it's vegetated.
Isn't there a lot of
The satellite, if you hit the satellite
That's another
view,
issue, so ledge, steep slopes, soil conditions, et cetera, et cetera. And, well, likely that parcel's got all the above.
It does.
I mean, it
That's
looks like a
actually
field, but
reference
it
in that.
looks
The stream
unless it's
flows north.
unless it's a vegetated pond, it looks like,
If I may speak, I'm actually,
The other half.
I'm
okay,
You may.
potentially looking at buying the other half.
okay.
That pond is exactly what it looks like. It's a very kind of brushed over grassy pond. But to the east of it, there's a very high and dry established logging road around it. So there's very good access to go around to the east of it.
Yeah.
And what we would be planning on is the house that would go on the eastern side of the lot would be probably pretty far above it, away from it. There's some. This is the eastern side.
Correct.
Yes.
Correct, yes.
And that looks like the logging road.
Yes.
Yes, exactly.
There's actually, and as you go up, the views get much better. You can see quite a
Where's
few
the
mountains
outlet
as
from
high
the
you go up.
pond? Where's the outlet from the pond?
So there doesn't appear to be a southerly outlet from the pond. It appears to just naturally leach out right there. The water flows down the land, kind of right down through the middle, and it all collects in the pond, and then that's it. There is no outlet. The ground, the land actually rises back up to fairgrounds.
There's also the logging roads, there's multiple logging trails in there, and there's one on the south side of the pond that's, like just Ben mentioned, is elevated, and it's approximately 100 feet in width also. So it, like he said, the pond actually seems to dead end there, and it's all just from the creek coming down the hill.
It's very deep, from where the road, the driveway or the logging road would be to the bottom of the pond. I mean, it's gotta be a solid 15 feet in elevation, if not even more. It's a very low depression right there.
Could be a bog.
Vernal pool.
There's no outlet.
Right. It could be. It's, fortunately, when we're looking at it, it's snow-covered and iced over. But you can see that there's vegetation growing up through the snow and the ice. And when we first looked at it, I thought it was like a meadow.
Yeah.
And then when we looked at the plans, we said, oh no, it's a pond.
Maybe.
Got some standing water.
Yes.
Could be wet.
So I guess that was my big concern, is that we would be able to get access for 2 lots.
So
Mike?
technically, if we do have a road here, you could have 2 lots, 2 driveways, or 2 homes off of here and 2 homes off of here, correct? Unless you wanted to build a road, which gets pretty expensive
Yes.
to access more lots.
Look, Mike, just to clarify, I think if we are subdividing it and you want to use Chase, like the Chase it's called?
Yes.
If you built a road, you might gain frontage. Currently, there's no frontage, and you would need presumably a variance to actually, yeah.
Right.
So it's not just building a driveway there, it's creating frontage, which would require a road probably.
Right.
Or getting a variance not to have one.
Question, if there's only, would be one house off of Welch, would we still need to do that? Or would we need to build the road if we were gonna put in multiple building lots?
Well, the question is the frontage. So you're required to have frontage on a road.
Okay.
And currently you don't have the minimum frontage.
So
If
we
that was,
have-
if it was split east-west.
Okay, so we'd have to effectively create frontage on Welch Drive by extending Welch Drive into the property?
I think that could potentially,
So you can access one lot through Welch Drive, the other through the frontage on Fairgrounds,
Just by putting in 2 driveways.
2 driveways.
Correct.
But then there's other things that we don't necessarily deal with here, but shared driveways and easements and
Yeah.
all sorts of mess that you might have heard a little bit about in the previous application that we were talking about. The other thing is the back lot.
Okay.
So,
I'm not sure, I was looking at the back lot, I'm not sure.
I find it confusing.
It's
Fully-
very, I thought it was just me.
Agreed.
And the people I talk to, they find it confusing.
Yep.
I'm not sure it would apply here, but you can tell me
I mean,
otherwise.
I'm not sure.
You know the lot number?
Back lot and adjacent front lot must both be on the same street. Which doesn't make sense because we're talking about one of the lots not having frontage, but the back lot and adjacent, I think it just allows for a, these are like flag or hammerhead lots.
There you go. The
So-
yes.
So
the
you can
last
have
image you were just
two
looking at.
50-foot, from what I understand, because we're in the ag zone.
What
So
page
you,
are we on?
are we in, yeah, we're in the ag zone there, right?
Yes,
Still?
that's
Okay. So you need 150 feet of frontage in the ag zone. The back lot and adjacent front lot must have a minimum combined frontage on the same street equal to the minimum combined front lot frontage of 2 lots. Okay, so there's not enough there.
Yeah, so that's what I was seeing that
Yeah,
we didn't
okay.
have, yeah.
I had to read it out loud and
Yeah,
confuse
in my
everyone.
opinion, this is not a backlot.
Yeah, okay.
Nor would it be if they put one single line
Yeah.
bisecting this large parcel.
Yeah.
This image is classic for backlot and flag lots.
Yes, yeah.
Just,
yeah.
just prior, yeah.
I just needed to read through that and be confused by it.
My recommendation would be to check more of the NH, if you've heard of the NH Granite website,
No, I haven't.
so you should write that down, NH Granite,
No E.
and you can find all sorts of stuff you want to find about development anywhere in New Hampshire. Soils, topography, LiDAR, all sorts. So turn that on to understand what it would take and how long and roadway or driveway, lengths, slopes, soils, all that sort of thing. Once you think you have a plan, sketch something out and go see a consultant. Go see someone like Al Barnett, a surveyor, someone like Neil, a soil scientist. And I think what you are asking, what you would like to do, is very, very plausible. And the reason I say go see a consultant, because I would tell you that is one use for this land. It is not the highest and best use of this land.
Well, yes, okay. I understand what you mean.
You've got access here and here, you could do a road that comes back around. Is that what you're saying?
You could, you could, I mean.
It's just expensive to build a road.
That's
but-
Absolutely. I'm not
That's
saying,
the stop.
I'm not advocating development, although I am, but you do what's right for you.
Right,
That's
right.
your opinion. But it is one use for the land.
Yes. Yep. And it's lots to consider for sure, but that's kind of, we both were looking for a big piece of land close to civilization, and this seems to fit the bill. If, but that's obviously could be possible too from reading about subdivision stuff. And you said that site was
NH Granite, Granite.
okay. I got it. Yeah. So.
We're not looking to put in a development or anything. We're just looking at how it's a nice piece of property, has a lot to offer. We both have interest in, he wants to build, Rick has just retired, he's looking to build his home up here and live up here permanently. I'm looking to have more than just the 1 acre I'm on now. And we're both looking at, there's a beautiful grove of sugar maples, so we're looking at doing some sugar mapling and maybe a couple cows and stuff like that. Just, we both want to have the land, but have equal share in it, not I have a house on his land or so on and so forth. That's really what we're trying to accomplish. And just make sure it's possible with what we have to do to accomplish it.
And if when we say, just to reiterate, when we say make sure it's possible, we can't, of course, guarantee anything here tonight.
Right, exactly.
But we can help guide you through the process. Yes.
Basically, just make sure it's not an automatic no, pack up your stuff and get out.
Yeah.
And there's no fatal flaw that we're overlooking that anyone
So-
here notices.
Rebecca had said 150-foot right-of-way per lot, combined if it was one lot, so that would be 300
I said 150 feet of frontage.
frontage. So
So
that
then
would
190.
mean, if what they want to do is 2 lots,
But that's a new subdivision. This is an existing parcel with existing frontage. Again, if it were divided, then that frontage would not meet. So that's just a matter of a variance?
that's what I was getting at.
Yeah.
Right.
To be
And-
accessing 2 lots from the same place.
Right, with less, only 180 foot of frontage.
You said it was 120-ish?
It's 119.
119.
119.
Okay, 190, right.
188.
But it's also kind of interesting in the subdivision plans. If you look up the definition of a driveway, it tells you, can actually quote, I'll try to, a private vehicular access serving 1 or 2 lots. And then under Article 7, Section Q, it mentions, it's a little, like you say, it's kind of confusing, but it seems to mention about up to 2 lots in a subdivision can share the same driveway.
If they have the road frontage.
And
But the
and
road,
an easement presumably as well.
correct, I would agree.
Where is the
But at
shared-
the same time is, if it's a driveway, does it need the full width of a 100-foot house lot or 75-foot house lot? Because it's just a driveway, as long as you're 15 feet from both property lines.
We're talking about a shared driveway here.
Yeah, so when
Yes.
appropriate, land may be subdivided into no more than 2 lots with access for each lot by a driveway as opposed to a street, provided that the plat carry a condition that should the lots be re-subdivided in the future, the driveway must be replaced with a street built to the specifications of the subdivision regulations at the time of the subdivision.
What's the minimum width for a driveway?
25 feet right of way with a 10-foot process way. A class 5 road, which is for subdivisions that have over 3 houses or more, is a 50-foot right of way with a 24-foot wide process way.
That's how I remember it.
He's dead on.
I'd like to recommend, sir, you read RSA 477:1 through 56, which describes the deeds in New Hampshire. I think you'll find annotation 23, talks about driveways, easements, and such.
Copy right here,
It gives you a whole description of your deed and what you should be looking for, and why you need to obviously hire an attorney to make sure that each property has legal, lawful, and valid descriptions contained in there.
Actually, that's a pretty private piece of property. It's
Yes.
isolated.
It is, it's pretty nice.
That's why we both like it. We've walked it several times, and it's very unique to be isolated where it is, but then you're right there.
Yeah. 5 minutes from downtown Plymouth.
Yeah.
So I guess a few that, yeah, Peter.
Yeah, just one last thing. So the reason I suggest and advocate you do your sketch and then meet with some consultants, and the reason I chose the specific phrase highest and best use, while that's not your use now, any development, processing of this land that you choose to do now should keep in mind future use.
Okay, good
In other words,
suggestion.
don't plop your house right where a road or right-of-way could be. That could take your 30 acres and turn it into 15 lots. If
Okay.
someone wants to put a road in, or 10 lots, or 5 lots, or whatever.
Good, excellent point.
And not only to be nice to future developers, but also to presumably raise your resale value as.
Well, I mean,
Or you could plop it right there and just say you're never going to develop it and keep it open
that's
space. and-
right.
Do that too.
That
Turn it to
might
your
be good
kids or
too.
your estate and let them deal with it.
That's, probably-
Turned it into one
You know,
public trails.
it's interesting when you watch Yellowstone too, to see some of the property that people own.
Yeah, this is no Yellowstone.
No, I get it, but it's just,
You can spend your children's inheritance.
So it sounds like what we're seeing is, we talked about a variance, which has a high barrier.
yes.
But you might consult with someone, as Peter was saying. There's creating frontage by extending the road. And then there's the shared driveway. It seems like those are the three things that people are talking about here.
I think also too, just if this were to come before us as a subdivision, just making sure that you're familiar with our 20-year-old subdivision regs so that you're adhering to the requirements.
Or whoever's
For the-
helping you is fully familiar with this.
Right, yeah. And there, there's going to be requirements for topo lines and elevations and wellhead areas and things like that, so just making sure that's covered.
And if that's giving you too much of a headache to think about that, that's when hiring someone like a
Yes.
professional, which either way is probably a good idea, just.
Yes, at some point, that'll be it, and that's basically, we'd come up with about the 3 scenarios that you guys all articulated. So,
We have already consulted with someone, started a dialogue with them, and it was actually his idea to approach the board and just bounce some ideas, have you guys bounce some ideas back, and at least just, like I said, start the dialogue. Try to start them right.
Yeah. Do you have any other questions for us?
no, I think we're good, right? Did we have anything else?
I think exactly what we thought.
Is there one more option where they could put 2 homes on that lot with one driveway?
I think they've said they don't really want to have 2 homes in the same owned lot, right?
Yeah, we figured that would just make a headache for someone down the road once I'm passed, I'm passed away. And,
Well, if they
we
got a
thought we'd avoid
variance, they
that,
could do that.
especially after sitting here tonight. We'd be like, yeah, we'll try to keep things squared away. So
It's a lot easier to subdivide first.
our ancestors aren't here fighting this out 30 years from now, 40 years from now.
Yeah, because I'll still be here.
Where the sewer line is.
I believe there is.
There is on Fairgrounds Road, there's water and sewer, but
I don't know if they'd want to hook on, though. It's such a long.
yeah, and we're, trying to get up a little in elevation for the view, so.
I think we're gonna be well away from it.
I gotta say, it's nice to be on the sewer line if you can hook up.
It is.
I mean, yeah, there's a monthly bill, but at the same time, you never have to worry about replacing your
Septic and
your
stuff.
septic system, pumping your tank.
Should
And
you do
your
every
sewer rates are
three
pretty
years?
reasonable, but where I come from, the sewer rates are really high. Almost $2,000 a year now. So that's a little bit of septic. But no, it's duly noted. That was always my point until the rates get so high where I live now.
Yep.
But we do appreciate the board and
Good luck.
yeah, thank you very much. Appreciate it.
Have a great night. All right. Other business from members of the board and planning staff. I just wanted to say thank you again for all the zoning amendment help, effort you all put in. The warrant info is officially public and published at this point for the 2023 town meeting, and the ballot voting, of course, is Tuesday, March 14th.
Can I put in my public service announcement that I do every year?
Yeah.
So it comes with a story, and it'll be quick, but my first year on the board, we had a fairly controversial zoning or amendment that we put forth to the board, and I didn't know that we weren't voting on it at town meeting. I just didn't know. And that zoning amendment tied. So my vote would have mattered. So don't forget to actually go to election day.
Well, I think election day is also the first day of town meeting officially.
Well,
Although
it's not when town meeting is.
It's not the
Yeah,
meeting part, but.
Go to the
yeah.
election as well.
Yeah, go to the
If you
election.
want to cast your vote.
Town meeting is actually on election day, and then you vote to adjourn to reconvene the deliberative session the next day.
Yep.
More eloquent way of saying what I was saying. Thank you.
Yep.
All right. And of course, you should have all gotten the revised planning board schedule for this year that Joseph sent out. And thank you for compiling that, Joseph.
Thank you, Joseph.
And I would remind us about reappointments, but I'm reminding myself and Mark, who's not here. So.
Me too. I think technically I'm up.
Are you up?
Yeah, I think I was appointed 3 years ago, but
I thought
they said my term was good through 2024, but.
I think what happened was at some point, I think we sent in like a mass reappointment, so we could all be staggered properly again. And so I think you may have gained that extra year in that
Maybe.
process. I don't think you're up.
But I don't know that there's, I mean, unless you can find a record of that letter that was submitted or approved by the select board, I'll just reapply.
Yeah, I'll confirm what it says on the confirmation papers from the, with
Although
the
by
town clerk.
reapplying now, you are kind of obviating what we were trying to do that time around, which is
Just
stagger
to
us.
stagger. But I would hate,
To be serving illegally.
I don't think we're going to kick
I
you
would hate
off.
to have any decisions made by the board questioned if I wasn't a member.
I'll double check the confirmation papers, and that has the expiration date of the term, so I will make
Yep.
sure we have that.
Yeah, so the confirmation paper showed the expiration date as the 24th, but then I think you found something that said when I was originally appointed, it was, I don't remember though, maybe I was appointed for a 1-year term initially, and then I don't remember if I was reappointed
I
the
think
year after. for
June
3
sent
years.
in a reappointment for a whole bunch of people at once.
Yeah.
To get everybody
I do remember
properly
her trying to do that.
staggered.
So you could just maybe do a 1-year term and then do it again.
Let's figure out.
Yeah, we can get in touch with Josie, the town clerk, and make sure we have what her records are as far as terms and nominations.
She's the official one, right? Right. Thank you.
We can prolong this conversation.
You guys are arguing over who's going to move to adjourn?
Wait, we're not quite there. Are there public comments?
Cryptic message, huh?
There's one public comment.
Ah.
Hi, Frank.
See?
This is just a point of information. I have been reading a book called Surveying and Boundaries, and it's all about regulations of land ownership. And one of the interesting RSAs that I came across was RSA 474:5, which is anyone who owns property, it's improved, aka has a house or driveway next to an unimproved property, such as a farm, is supposed to remark their boundary lines every 5 years. And this was established back in the 1800s. There were a lot of court cases of people not knowing where their lines and complain about somebody building on something on their property. So the courts established this RSA, and it's a massive fine of $5 if you fail to comply. But it does help people to know where their lines are and their bounds to remark the trees or monuments that have been put in the soil. So they're currently knowledgeable, because after 20 years, somebody can file for a quiet title on your property that you thought you owned. Piece of info.
Adverse possession?
Yes.
Yeah, every time you pump your septic system. I mean, no, sorry. I was saying every same time frequency.
Oh, okay.
Supposed to pump your septic every 3 to 5 years.
I am
flag your
fascinated by the
property.
concept of adverse possession, and that there's actual legal standing for that.
Yep.
Yeah.
It's Old English law.
Yeah.
Right.
All right.
We live in New Hampshire.
Any other public comments? Okay. Let's sit back.
You ever heard
Sue?
See?
You got anything for us?
I'll make a motion to adjourn.
You want a second?
Why me?
I'll second.
I was trying to take
Then
the
I'll
heat off.
second. I'll second.
Okay, we have a motion to second to adjourn. All in favor?
Aye.
Opposed? We are adjourned. Have a